And on that note, hello again. Good morning. This is Catherine Henry. We are just having so much fun with this constitutional amendment petition and all that it entails that we just are so excited to share some stuff with you. But this particular video is actually just to give you a brief highlight or update on the legislature's case with the governor. So, with that being said, okay. So for those of you who maybe forgot or you need kind of a refresher, so the legislature filed a lawsuit against the governor saying that she does not have the right to continue her executive orders after April 30th because they did not give her an extension of the emergency powers. They filed that in the Court of Claims, which is like the trial court, and the trial court judge said, okay, the governor did violate the Emergency Management Act of 1976 because she's going beyond the 28 days without a proper extension. However, the trial court judge then said, well, she does get to go under the Emergency Powers of the Governor Act all on its own, as though we get to cherry pick our statutes. So at that point, both the governor and the legislature filed appeals with the Court of Appeals. Then they both asked the Supreme Court to allow them to jump over the Court of Appeals step and for the Supreme Court of Michigan to take the case right then and there. So the Supreme Court issued an order on June 4th that accepted my amicus brief on behalf of the people of the state of Michigan and those who want to defend the U.S. and Michigan constitutions. That's the basis for which I submitted the amicus brief. So they accepted my brief, and then they also accepted or granted the motions to decide the jumping over question quickly. But then in the same order, they turned around and said, well, we've decided, but we're not going to let you jump over. We will get to that when we get to it. For now, we're going to have you go to the Court of Appeals. Shoot, I have two orders that are underneath that one and the one below. Okay, so speaking of the orders, it might be helpful if I actually had them in front of me. Thank you. Okay, so the one from June 4th, in this case, it's interesting because, well, anyway, so what they did is they said, the Supreme Court said, okay, we're going to send this case back down to the Court of Appeals. So at that point, so at the higher level, at the Supreme Court level, the legislature filed a brief, the governor filed a brief, I filed a brief, the interveners filed a brief. That's those 5 attorneys that were basically planning on suing the governor anyway, and they thought it would be judicially efficient if we just allowed them to join in as parties in the case against the governor here. So we all that I just said, the 4 briefs were filed with the Supreme Court. Then the court kicked it back to the Court of Appeals. So at this point, there it is. At this point, the legislature filed their brief on appeal for the Court of Appeals. Excuse me. The legislature filed their brief. The interveners filed their brief because they were denied the opportunity at the trial court and the Supreme Court to join in the case. So they've appealed that again. And then there were some motions filed. So basically they're asking the court to put this on an expedited docket to hurry it up, move it along, and issue a decision. So far, the order from the Court of Appeals that came out, I filed that away, says that they're going to put it on an expedited docket, so to speak, but oral arguments are still going to be heard in August. In August. That's when the Court of Appeals is planning on hearing arguments on this case. Directed to be placed on the August 2020 case call. So, okay. Then we've had some amicus briefs filed at this stage. One is by attorney Carrie Morgan. It is not so much in support of the legislature's position, but definitely against the governor's unconstitutional actions. And then there was another brief, an amicus brief filed by the House Democratic leader. Let's see, I think there were 2 more. That was later. shoot. There was one other one that I don't remember. That was an amicus brief filed. Then there was yesterday, I believe, there were two amicus briefs filed. There was one filed by a professor at the University of Michigan who claims that he's not filing on behalf of either the governor's position or the legislature's position. He claims that he is just focusing on the constitutionality of whether the governor can issue these orders. You guys should read that. I mean, it's not a very long brief, but he's basically saying, well, everybody agrees that she had the right to issue all these directives and restrictions before April 30th. So because of that, it's obviously constitutional afterwards. No one agrees to that. I've read the briefs. The only people that agree to that are the people that think the governor is this awesome person that gets to yield whatever power she wants to. But no, the rest of us do not agree. And the Supreme Court justices don't agree either in the order that they issued on June 4th. It's pretty clear. But for some reason, he seems to think that everybody agrees that the governor could have done whatever she wanted to us as long as it was before April 30th. Okay. So, and then I filed my brief. So, I filed a brief with the Michigan Court of Appeals about 10 hours ago or so, to participate as amicus, to continue to participate as amicus. Let's see. Okay, so here's a couple of key points. I'm going to try to do this super quick. That came from the June 4th order from the Michigan Supreme Court, okay? The order itself is only these few sentences right here. Then everything for the next 18 pages is either concurring opinions, which means a judge or justice agreed with the outcome but wanted to specify why they thought so, or a dissenting opinion, which means they don't agree with the outcome and they're explaining why. So, okay, so Justice Bernstein, who's actually concurring, says that he agrees that this case presents extremely significant legal issues that affect the lives of everyone living in Michigan today. Yep, sure does. He also recognizes that not all the restrictions have been lessened and acknowledges the possibility of future restrictions being implemented. Yep. He says the significance of this case is undeniable. Sure is. Let's see. There's a lot of silliness in this one, so I'm not even going to read that. Okay, then you have... What's that?
2 questions when you're done.
Okay. Justice Markman. I would grant the application, basically the application meaning the ability to jump over the Court of Appeals and have the Michigan Supreme Court issue the order right away, or to have them handle the topic directly. That's what they're talking about when they say applications. So Justice Markman says he's dissenting, and he's saying, I would grant the applications because they pertain to an issue of the greatest practical importance to the more than 10 million people of this state, the validity of the executive orders declaring a state of emergency and thereby enabling a single public official to restrict and regulate travel, guaranteed to us by the Constitution, to restrict and regulate assembly, business operations, educational opportunities, freedoms, and civil liberties, and other ordinary aspects of daily lives of these people, including matters of crime and punishment and public safety. To put it even more specifically, the present applications place into question the entirety of the processes and procedures by which the executive orders that have defined nearly every minute and nearly every aspect of the lives of we the people of Michigan for more than the past 2 months were fashioned into law. Exactly. There's not much more that you need to say about that. Okay, then he also says that he would grant the applications because time is an altogether relevant consideration that to what is required of this judiciary. Our state moves on in the midst of an emergency in which both the lives and liberties of its people are being lost every single day. Lives and liberties. So, let's see. I think she's here, so just for what that's worth. Justice Zara says in his dissenting opinion, this case, the legislature's lawsuit against the governor, presents palpable constitutional questions that are of compelling interest to every resident, business, and employer in Michigan. The instant matter is arguably the most significant constitutional question presented to this court in the last 50 years. Can you guys answer it? It's her. By granting the applications, by allowing... Can you have Ashley tell her I'll be right out?
Yeah.
Thank you. By granting both applications, the court could put to rest with finality whether and to what extent the legislation on which the governor relied to issue the serial emergency COVID-19 orders remains a valid source of authority for those orders. Admittedly, it's not an easy task, but the people of the state rightly demand that this court resolve such difficult questions. Because each resident's personal liberty is at stake, it is emphatically our duty to decide on this case. Life for people throughout Michigan was turned on its head on March 10th when she issued that first order. That's Justice Zara from the Michigan Supreme Court. The governor issued numerous additional statewide orders generally requiring people to stay at home unless their departure from home was essential, closing all non-essential businesses, closing all schools before the end of the school year, and seriously restricting travel, assembly, and other aspects of daily life. Law and non-emergency medical offices throughout Michigan were closed indefinitely. Let's see. No issue, I think this is the same, or is this Justice Viviano? Nope, this is still Justice Zara. No issue is of greater public interest or importance than the resolution of whether the governor was within her constitutional authority to deprive the 10 million plus residents and the thousands of business owners of Michigan of their personal freedom and economic liberty. This is out of the words from our Michigan Supreme Court justices. The people of Michigan expect this court to resolve this dispute, and we should do so. Both of our co-equal branches of government have asked for these significant constitutional questions to be answered as soon as possible, and the people of the state have a great interest in the final disposition of these issues as soon as possible. Hence the reason, part of the reason why the legislature's attorney also recently filed a motion to reconsider, to have the Supreme Court reconsider taking on the case right now and not waiting for it to go through the Court of Appeals. Okay, let's see.
And special status to move it before August.
Right. So Justice Viviano also recognized that, let's see, that this is a case that impacts the constitutional liberties of every one of Michigan's nearly 10 million citizens. A substantive ruling on the merits of this case by our court, the Supreme Court, would not only provide clarity to the governor, the legislature, and the public, but it would also assist the lower courts as they continue to address these issues in other matters. Justice Zara also says that the public is an aggrieved party. Let me see here. This case, oh wait, is this Justice Viviano? This is Justice Viviano, this last one, I'm sorry about that. This case involves some of the most important legal principles that can arise in a free society. These issues and how we decide them will have a direct impact on the constitutional liberties of every person who lives or owns property in or simply visits our state while the restrictions are in place. Who lives or owns property in or simply visits our state while the restrictions are in place. On a fundamental and practical level, they impact how our friends and neighbors live their lives on a daily basis, where they can go, with whom, how, and when they can practice their religion, whether they can go out to eat or to the hardware store or to the beach. In short, nearly every decision they make about nearly everything that they do. Our court exists to vindicate the constitutional rights of our citizens and to be the final expositor of state law. Thus, we are uniquely situated to provide a prompt and final resolution of the issues presented in this case. Anyway, that's all the time I have for today. I am over time by about 8 minutes. Is it a super quick question?
They want to be able to read that brief. I don't know if we can get it posted.
The one that I drafted?
Yours and the legislative one.
Okay, I will see what I can do about uploading the other briefs, but I believe that my website team is currently making sure that our press release from earlier this week with the Restore Freedom Initiative is posted to the website. We have a new logo. Well, we have a logo now. We didn't have one before, so that's being uploaded. My brief that I uploaded that I filed with the Michigan Supreme Court is being uploaded. My brief that I filed in the Michigan Court of Appeals is being uploaded. My motion for the court to accept my brief at the Court of Appeals level is being uploaded, and I will see about the other ones, but I have to take off right now to head to Lansing to speak at the Medical Freedom rally.
And the last question is, I thought the courts had to respond in a timely manner, 21 days. What happened to that?
But the courts have to respond in 21 days.
They had to hear the case in a timely manner, 21 days.
Yeah, I don't know what that person's talking about. So unfortunately, I can't dig into figuring out what the basis of that question really be, so I can try to make sure to explore and give you an answer. I do have to go, but I will try to provide updates as I get those as well. And I look forward to seeing you guys in Lansing today, or where am I tomorrow? In Detroit tomorrow, or Traverse City, or Rothbury, or Freeport this weekend, or Jackson, or the Deltaplex in Grand Rapids on Monday or Tuesday. Thanks, guys. Have a great day.